Hello, my name is Katie Burley and I'm an associate here at Seymour Park Solicitors. In this webinar today, I'm going to be guiding you through the running of a standard redundancy process. This webinar is going to be in 3 parts. The first part, which you're going to watch now, is going to be an introduction to redundancies, and we'll cover key things such as the law behind redundancies, pooling and selection criteria. The second part is going to cover the consultation meetings which you'd need to hold with your employees, where you really get in front of them and get involved in the step-by-step process. The third part is really going to cover some ancillary matters, so suitable alternative employment, payments made redundancy and those sorts of things. Dealing with redundancies can be a daunting prospect for both employers and employees. It doesn't tend to be anybody's favourite thing to be either on the receiving or the giving end of redundancy matter. The fact is that redundancy can not only be quite emotive in nature, which makes the process immediately tricky, but there are also lots of steps that employers will need to follow in order to make sure the redundancy dismissal is fair. On our first slide, we will see that redundancy is one of the 5 potentially fair reasons for dismissal. The statutory definition of redundancy covers 3 types of situation. Firstly, business closure, secondly, workplace closure, and thirdly, reduction of workforce. Now, before actually starting any sort of consultation process, employers must be satisfied that the statutory definition of redundancy applies. Now, in order for that situation to arise, one of the following must apply, and you will see these on your slide. Either the employer was ceasing or intending to cease to carry on business for the purposes for which the employee was employed. Now that's your business closure, so where a whole business tends to be closing down, and there's quite a few redundancies as a result. The second is the employer ceasing or intending to cease to carry on that business in the place where the employee was so employed. Now that's typically where that's your workplace closure, so you've got one branch, for example, in a multi-branch organisation that's closing. The third one, as you can see on your slide, is where the employer has a reduced requirement for employees to carry out work of a particular kind, or to do so at the place where the employee was employed to work. Now that's your reduced requirement for employees. So if you've got, say for example, a department of 20 people, you only have enough work for 5 of those people, you're going to be looking at reducing those roles in order to be able to just supply those who you do actually have jobs for. Now on the next slide, I've very briefly touched on collective consultation. This is actually a very complex area of redundancy, and unfortunately it's far outside of the scope of what we're going to be able to talk about today. What I just wanted to do really was to flag out some key points, or some triggers as it were, so that if you are in a redundancy situation, you can make sure whether or not a collective consultation process actually is going to apply. So, what you need to do in order to establish whether a collective consultation process is going to apply is firstly establish how many employees are going to be affected. Where 20 or more employees are going to be made redundant over a period of 90 days or less, firstly, you must inform and consult with employee representatives. Now, this is quite a different process to the standard situation I'm going to be talking about later. So, where you've got 100 or more redundancies being proposed, the consultation must begin at least 45 days before the first dismissal takes place. And for less than 100 redundancies, the consultation process is 30 days. So there's quite a prescriptive time period in which you actually need to follow for carrying out these consultations. Second thing you've got to do if you have a collective consultation process on your hands is notify the Secretary of State. Same sort of timescales and numbers for this. So where you've got more than 100 employees proposed to be redundant, you need to notify the Secretary of State at least 45 days before the first employee is dismissed. And where less than 100 employees are at risk, the Secretary of State must receive the notification at least 30 days before. Now, the reason that this is so important, the reason I just wanted to flag it, is that there are potential fines that can be put into place if you don't follow those quite prescriptive measures. So the tribunal can actually award up to 90 days pay in respect of each employee where there has been a breach of the information and consultation duty. So, you know, if you're talking about 100 plus employees, that could be quite a lot of money. You can also be fined if you don't notify the Secretary of State in the appropriate manner. So again, quite important things to bear in mind there. As I said anyway, this is outside of the remit of what I'm going to be able to talk about today. It's a whole different subject. So please bear in mind, as I'm going through the process now, I'm not going to be telling you about all of the various measures which you need to put in place for specifically for collective consultation. Now, the overriding principle for most employees is obviously to achieve a fair dismissal, and that's what we're going to be looking at next. On the next slide, you'll be able to see so that any employee with 2 or more years service is entitled not to be unfairly dismissed, something that most of you, I imagine, are quite familiar with. In order for redundancy to be fair, therefore, there are various things that you must do. The first thing is to establish that redundancy was the actual reason for the dismissal. Now, I think if I had £1 for every time that I had a client come in and say, I've got this dreadful employee, they're performing really, really badly, can I make them redundant? Well, the answer is generally speaking no. There does need to be that meeting of the redundancy test in order for it actually to be a redundancy situation. The second thing that you need to establish is that you have acted reasonably in treating redundancy as the reason for dismissing the employee. Now, this will mean that you must warn and consult the employee about the proposed redundancy. You must adopt a fair basis on which to select anybody for redundancy. So you obviously have to identify an appropriate pool for selection. You'll have to consult with the individuals in that pool, and you'll have to apply objective selection criteria to those individuals. The next thing you must do is consider suitable alternative employment. Now, that's actually something that I'm going to cover in the third part of this seminar, which is going to be a separate recording. If any of the steps that I've just mentioned are missed, it is very likely that your redundancy is likely to be found unfair if it ended up in a tribunal. Turning to the next slide, we will see that selection for redundancy on the grounds of certain things will actually be deemed automatically unfair dismissal. And employees don't need a qualifying period of employment to make those claims. Those will include the typical things that we see for all sorts of different types of dismissals. So if their redundancy selection was on the grounds of pregnancy or childbirth, if it was for whistleblowing, if it was for asserting a statutory right, for example, if they'd raised a grievance and then you skewed your selection criteria to oust that particular person, all of those types of things would be deemed automatically unfair, and the 2-year qualifying period of service would not apply. Now, contrary to popular belief, there is actually no mandatory process that needs to be followed for redundancy. The ACAS Code of Practice that we know for grievances and disciplinaries, this doesn't apply to redundancy situations, and so it doesn't need to be followed in these kind of circumstances. What you do need to remember, however, and you do need to check, is whether you have any form of contractual policy in place. Many employers will have some form of process that they would typically follow in a redundancy situation, which might be contained in a handbook or elsewhere on your systems. So do just bear that in mind and double check that before commencing any form of process. On the next slide, I'm going to cover timing. Now, a key point that can trip employers up when following a redundancy process is the timing. Now, I'm not talking about the length of the consultation. If we're remembering back to when I was talking about collective consultation a moment ago and the prescriptive time limits that you have to put in place there. The basic thing is actually when you need to start consulting with your employees. Now, the principal rule is that an employer should start to consult as soon as the risks of redundancies is actually established. Now, determining this can be slightly tricky, especially when you've got a situation such as a restructure situation where there's lots of different things happening. But the general rule, as I say, is that you do need to establish a particular point where you are aware that there is a risk that employees may be redundant, and that is when you are meant to start consulting with them. There is no prescribed timescale for a particular redundancy process within which consultation should take place. Depending on the complexity of the matters, this could actually be anything from a couple of weeks to a couple of months. It really can be that wide, and it will very much depend on the situation before you and the need to consult with those various employees. I would generally recommend giving at least 2 consultation meetings with at least another day in between those meetings so that you actually have time to effectively consider what's been said in the meetings and whether any changes do or should be made. I have seen consultation processes take place in a week, It's pretty rare, I have to say. It tends to be the sort of circumstance where you've got maybe 1 or 2 employees or very limited number, then you can get it done a little bit quicker. But generally speaking, the shorter the consultation process, the more likely or the more at risk you are of having that process to be found unfair. So we would recommend a couple of weeks as a minimum. Just as a side point, when you are considering your timescale, do bear in mind that if you do have to interview as part of that process, so you've got some roles that need to be filled and you need to interview various existing staff members to see if they're suitable for that role, you will want to make sure that you give yourself enough time to be able to follow that interview process and then actually make any job offers before any contractual notice expires. If you've got quite short contractual notice, obviously bear that in mind. So you're going to need to adjust your timescale accordingly. Now, on the next slide, you're going to see a flow chart for a basic redundancy process. Now, this actually takes you through, in a very overview, obviously not one shoe fits all, but in a general overview of the different types of steps that we will be going through both today and if you were to follow a redundancy process yourself. Now, I must stress that no 2 redundancy processes are the same. When putting this seminar together, I was conscious, obviously, of the fact that you can't really shoehorn this into a textbook situation, but I've done what I can with the time that we have. And so what you will see on that slide is, say, a step-by-step process of the basic type of redundancy scenario. On the next slide, as you'll see, through the journey of redundancy, we have already ticked off 2 of the boxes. We've established that we've got a genuine redundancy situation within the realms of the law, and we've also established that there's no collective consultation process required. So those are the first 2 steps. You'll be glad to know that some of the next ones will come a little quicker, but bear with me and we'll carry on. So on to the next slide. So the next thing that you would normally do is you will need to identify your pool of individuals. Now, this is really your starting point for the actual process. And there are no fixed rules about how a pool should be defined. Generally, as long as you genuinely apply your mind to the choice of your pool, so which employees you're going to put at risk of redundancy, the tribunal is reasonably unlikely to challenge it. They don't tend to get too involved in the pooling stage unless it's wildly inappropriate. When considering the employees that you're going to put into your pool, you are likely to want to identify the following. So firstly, the type of work that is ceasing or diminishing. Secondly, the extent to which employees are doing similar work. And thirdly, the extent to which any jobs are interchangeable between those various employees, so where you've got skills that could be transferred. Now, in doing this, you're going to firstly want to look at the actual work that the employees are doing. That's what we would recommend. Your job descriptions might be quite a useful place to do this. However, do bear in mind, if you issued your job description to an individual 10, 15 years ago and it hasn't been updated, then it's pretty likely to be inappropriate. It's pretty rare, I'd say, these days that you get an employee whose job doesn't develop at some point during the course of their employment. If you need to, you may well need to look at putting in new job descriptions to actually currently reflect their exact work, but that's something that you'd need to look at on a case-by-case basis. But just the key point really is to make sure that the current situation is what you're looking at. What is it that they do today? Where you've got lots of employees who are multi-skilled and do different work or can be required to do different types of work under their contract, a narrow pool can actually be quite difficult to establish. Ideally, you want quite a small pool because then you've got less individuals who are at risk of redundancy. However, as I say, where you've got multi-skilled type of people who've, for example, done other roles already within the organisation, it can be very, very difficult to narrow those people down. Generally, the lower skilled the work involved, the more likely this is to apply. And so you get individuals who can quite easily do the roles of other people. And in those cases, it may well be that your pool has to be wider to encompass all of those particular individuals. The other thing to bear in mind, obviously, if you do have multiple sites, you may need to consider whether to look at pooling individuals from other sites as well. On to the next slide then. So the next key step that you're going to be needing to take is establishing your selection criteria. Now, when you're establishing your selection criteria, as in the way that you're going to choose between these people that you've got in a pool of who will need to be redundant and who will not, as far as possible, you're going to want to make sure that it's capable of independent verification. which really means that it's measurable rather than just being something that can be judged on somebody's personal opinion. Ideally, criteria should therefore be measured by things like HR records. They can cover things such as appraisals, performance records, attendance, disciplinary records, those sorts of things. Because at the end of the day, if you've got an appraisal that's been, you've sat down with your employee at the end of each year or however frequently you do it, you've told them that they've got these issues. It's pretty difficult to challenge that if they haven't already challenged it previously. So if you can base things on paperwork, it just really helps to make sure that it's slightly more watertight than just the fact that their boss doesn't like them very much and has given them a particularly low score. You must bear in mind and you must ensure that you do not include any types of criteria which could be deemed discriminatory. So for example, if you're using attendance records, you're going to need to make sure that you discount any absences for sickness which is related to a disability or indeed for maternity related reasons. Just because somebody's had a year off on maternity doesn't mean that they get a massive year marked against their name for sickness purposes when it comes to redundancy. So do make sure that you don't make any mistakes such as that. Likewise, any redundancy selection criteria that discriminate directly, especially on the grounds of any of the well-known protected characteristics or on the grounds of fixed or part-time status will generally result in a finding that the dismissal is unfair. So be aware of those as well. Further to this, on the lines of discrimination, we've also got the realms of indirect discrimination. So any criteria that have an indirectly discriminatory effect are also likely to render dismissals unfair, unless, and you obviously have a defence for this, unless you can demonstrate that there is an objective justification for their use. I'm not going to go into this because this is a whole other area of law, but I just wanted to flag it so that you're aware. Where possible on the size of your organisation, if you can, it's very useful to get more than one manager carrying out your scoring, especially if there's any slightly more subjective criteria being used. It just helps to back that up, so it's not saying that one person is particularly picking on someone. We've seen this many times in tribunal claims that we've run here. On the next slide, you will see that there are some examples of potentially fair selection criteria. So we have, as I said before, disciplinary records. That's a very typical one. Attendance records, as I said, very useful, but do bear in mind any potentially discriminatory elements in there that you'd need to remove. Performance and ability and skills and qualifications are again very, very useful types of things to be able to sift between your various employees and score them accordingly. As I've said, performance and appraisal, performance and ability, that will typically cover appraisal records rather than relying on the manager's personal opinion at the time of the selection process. This is one of the reasons that we say time and time again to our clients, please do appraisals. They're so valuable. They're really, really worthwhile doing on a regular basis, at least once a year. First in, last out used to be a very popular method of selection. It's really less advisable these days, pretty much due to the fact that it is very, very likely to give rise to a finding of unfair dismissal on the grounds of discrimination in relation to age. So we would recommend that you don't use that one anymore. Whilst case law has shown that such criteria can be discriminatory, it has clarified that length of service can actually be acceptable if it can be objectively justified. There's a particular case involving Rolls-Royce and Unite the Union, which showed that they had the argument that they were making was that their legitimate aims for using that criteria was maintenance of a stable workforce during reduction exercise and rewarding of loyalty. Now, I should say that these may well sound very desirable and the kind of thing that a lot of people could look to put in place. However, I would use that very, very cautiously. It was one of many, many criteria that they used in that particular case. And as I say, it's not something that you should necessarily put in place without good reason. Last thing I'll just quickly mention is that you can actually apply weighting to any particular criteria to reflect their importance. If you do that again, you're going to need to have good reasons for doing so. You're going to really need to be able to justify it. You can't just bump up the weighting on a particular element, for example, disciplinary, because somebody's got a first warning, you don't like them very much, you'd quite like it if they went. So do bear in mind, as I say, any kind of steps you take will need to be justified. In line with this, when you have your selection criteria in place, you really must apply them fairly. There was one case that went through the tribunal where an employee who had an excellent attendance record, she was near perfect with her attendance at work, was only given 50% of the scoring for that element of criteria. Their argument was that the person who did the scoring was actually slightly incompetent in their role. The tribunal didn't buy it. They didn't think that incompetence was an excuse. You really just need to make sure that you apply this properly. So on to the next slide, and that's back to our trusty chart. You'll see that we've now ticked off a third box. Don't worry, I promise the rest are much quicker to go through, and we will make slightly faster progress in the next part of this webinar. So that neatly concludes the first part of this webinar. The second and third parts are also going to be available, and I hope I will see you then.